Hello to the world. My name is Neha Chugh, and I am here with Pulat Yunusov. And today I am taking over Pulat's podcast. I am taking the reins as the interviewer, and I am interviewing the one and only Pulat Yunusov. So we're changing tables here. We're changing places. Um, I'm so honored and excited to be sitting here with my friend and colleague, Pulat Yunusov. There he is with a big smile on his face. He knows he's in the hot seat today. He knows how we all feel when we're being interviewed by him. So now it's my turn to ask you questions because I was in the hot seat last week. So Pulat, welcome. Thank you for your time.
Hi,
And
Neha.
hi, where are you today? Where in the world are you today? I'm in Montreal. Where are you?
I'm in Toronto. I'm always in Toronto. Uh, I'm probably in Toronto 99.99% of the time, especially this year. And I'm in my sun-drenched office here. And I'm in a luxurious situation, I think, compared to many people, because many people are stuck at home. And I have the luxury of going away from home every day and sitting in my lair here where only my things are, except, I think there is my daughter's book is here. Sometimes I bring her to the office.
Wonderful. And what kind of law do you practice, Pulat?
I call myself a commercial litigator. So I think it's a branch of civil litigation where you focus on commercial disputes, you focus on transactions that went wrong, you focus on insolvency, you focus on debts, you focus on all kinds of things that can go wrong about transactions or property, or sometimes a professional relationship. So I do a bit of professional negligence as well.
Okay. And Pulat, you came to Canada from Uzbekistan. Can you tell me when you came to Canada?
Let me try to remember, it was a very long time ago. I came to Canada, this year will be the 21st anniversary of my arrival to Canada. And before Canada, I have to say, I think it's material. I lived in the United States for 2 years. So I came to North America in 1998.
And you went by way of the United States right to Toronto?
Yes, I drove into Toronto on Gardner, and I wasn't impressed. In 2000, when you were driving from Niagara Falls into Toronto on Gardner, you wouldn't be impressed. They had none of the glass towers, nothing like that. It was very gray, industrial looking at the time.
Did you ever think that you'd be, working in a downtown office and, rolling up your sleeves and doing commercial litigation of all things?
No, I had no idea. I didn't think I would be a lawyer. At that time, I was really interested in computer programming, and I was hoping to be a computer programmer, to work in technology and IT. So no idea that I would be a lawyer. Had zero idea, zero plan.
So you and I met at Osgoode Hall Law School. And tell me about your story. How did you get to Osgoode Hall? How did you go from driving up the Gardner on that gray day to Osgoode Hall Law School?
I applied to 3 law schools in 2006. I applied to U of T, Osgoode, and McGill. McGill accepted me on condition that I take summer French classes. And I said, well, I'll think about it, because another condition was moving to Montreal, obviously. Right at the time, I was already married. My wife had a job here. Osgoode accepted me unconditionally, and U of T was holding out, didn't send me any response to my application for a while. So finally, I walked into the U of T admissions office and I said, what's going on? Just give me the answer. Osgoode already admitted me
Mhm.
And as soon as I said that, I think the next day they sent me the letter saying no. So my theory is they thought, okay, this guy already has a spot, so we're going to give this spot to somebody else, right? So, or maybe I wasn't good enough. You know, it's U of T, right? Who knows? So I'm going to be as impartial as possible about myself here. But uh, Osgood admitted me. Why did I end up going to law school? Well, I guess I wanted. I like the sound of my voice. And I didn't get to hear my voice enough when I worked as a computer programmer. I worked as a computer programmer for years before. So I did start working as a computer programming after I came to Canada. And I worked as a computer programmer for years before going to law school. But I liked the sound of my voice so much. And I never really got to hear my voice when I was a computer programmer. And I never really got to see any admiring audiences listening to my speeches and submissions. Not that I see them now. I mean, it's very rare that somebody admires my submissions. Very rare. But yeah, I guess I was really young. It was many years ago. It was what, 14, 15 years ago, right? And I just thought, okay, I'm gonna try that because it sounds like fun. It sounds like lawyers have influence in the society. And I was somehow interested in this concept of influence. I wanted to have influence. I wanted to have a say in Canada. And I wasn't a big believer in political participation because I thought I'm going to be one of 30 million people, right? It's not too much influence. So if as a lawyer, I can directly influence specific cases, right? So I think that was my reasoning, and that's how I ended up applying to law schools.
Okay, and you said that you were married when you applied to law school. Can you tell
Correct.
me about that? Because a lot of students who go to law school are younger, they're in their 20s, and you were married,
Yeah.
and uh, I'm assuming, I never ask, that you were a mature student, that you were older than a lot of your cohort. How did you find that in law school?
I think I was about 10 years older than the average age of students in my Osgood class. I didn't really feel that difference because I didn't have kids at the time. I don't think you're really mature until you have kids. So um, it was good. It was okay. I mean, I had more life experience than most around me, but I didn't really get to show that off because nobody was interested in me. Right. So I was interested in other people, but very few people showed interest in me. People mostly showed interest in their computer screens and summaries and things like that. And uh, I wasn't really a big bar, pub, going out type because of the marriage, right? So you have to spend time with your spouse.
Right.
That's my advice to all people who are married. You have to spend time, pay attention to your spouse. And
Is that your legal advice, Pulat?
no, no legal advice. No legal advice. And I don't practice family law. But the thing about Osgood, though, there were a lot of really nice people in my class who eventually started paying attention to me, and we became friends.
Right.
And because I think that's one of the few upsides about being in law school for 3 years. I generally don't think it's a good idea, the length of time it takes to get a law degree, but that was at the upside. You're with these people for so long, eventually you figure each other out and you become friends, right? Even with a goof like me. So and that eventually became one of the biggest sources of support for me as a lawyer. All the friends like you and like others, you can find many of them on the list of guests of my YouTube show. And over the years, we kept in touch. Over the years, we went out to have lunches together, we talked, and I learned a lot from them over the years because they were exposed to different firms. I was exposed to Yunusov Law Professional Corporation most of the time, right? And they were exposed to a bunch of different firms. And I learned a lot from them. I followed them, and they referred work to me also. So that was amazing when it started happening. I realized that people are great, and people are really the most important thing in one's life, because they support life, they support work, they support you. So treasure people.
So then tell me about your story leaving law school. Where did you article?
I articled at a small wrongful dismissal litigation firm. It was very hands-on. I had a lot of practical experience. So that helped me hit the ground running when I started my own practice right after my call to the bar.
And you started right away?
Yes, pretty much.
And how
days
many
after.
days after? And did you have a client list, or how did you
No,
start?
I didn't have any book of business. I didn't have any client list. I started very, very slow. So it was a minimum viable law practice, if I can borrow the startup terminology. First I thought I'm going to look for jobs, but then I realized I have a license to practice law.
Yes.
It's real.
Yeah.
It's real. I just spent 3 years and thousands upon thousands of dollars to get that license to practice law. So why don't I use that license a little bit? All I need to do is to get one client and to get Law Pro coverage. So the biggest obstacle to practicing law on your own at the time was the cost of the license and the cost of the insurance premium. But if you can take care of that, there is nothing that can stop you if you are not going to bite more than you can chew.
Right.
And by that, I mean, if you take a complex Superior Court case where large sums of money are at stake, you might be biting more than you can chew in your first, second year of practice. But the beautiful thing about clients is that they generally don't want the first, second year lawyer take $1 million Superior Court case. So they will probably not end up in land on your lap, those cases. But what will drop in your lap, and literally it will be like fruit dropping from trees, small claims. And I'm talking about only civil litigation right now. I've had almost zero experience with criminal litigation in my entire law school experience or career. Small claims is a wonderful arena and forum for serving clients and getting trial experience. It's incredible. And the stakes are by definition low, relatively low, right? They may be very high for your specific client, but I'm talking in terms of concern that law pro may have about this. So definitely small claims, and also landlord and tenant tribunal at the time. I remember the first couple of years of my law practice was trials. I just did trials, landlord and tenant trials, small claims trials. I know the trial experience is laughably small compared to any criminal lawyer's trial experience, right? I mean, any decent criminal lawyer would do probably a trial a week or something, I hear, right? But then I also distinguish criminal trials, most criminal trials, from civil trials, because I understand that in many criminal trials, there is a very distinct factual issue that is being tried. Did you touch that person with your body or not, right? In commercial trials, usually there's a complex matrix with a long history going back and thousands of documents. So this is a very different trial experience, although the skills are transferable. Cross-examination is cross-examination. So the first few years was trials, and that really set me on the course to practicing successfully, practicing civil and commercial litigation successfully, because I have a trial first approach.
And I want to ask you, first of all, I want to say, as a criminal lawyer myself, I agree with you. I found myself in the beginning years in provincial offenses court learning how to run trials because I don't want to use the term low-hanging fruit, but the opportunity is there, right? The opportunity to run trials, learning how to call evidence, it's all there. And young lawyers should take that opportunity to take the trial first approach. Um, I agree with you. The other thing I wanted to ask was how, as a computer programmer, have you been able to transfer your skills to incorporate technology into your practice? And do you see that as an advantage in your practice?
That's a great question. I'm actually on a Law Society panel, I think this May, where we're going to discuss making your practice tech friendly. So I look forward to that panel. I've been digital, and my practice has been digital and paperless since day one. I didn't have a choice because I couldn't afford a lease. If you can't afford a lease, you have no choice but become paperless. And I know that this is why 20 years ago, people didn't really start their practices. Many people couldn't start their practices right out of articling because they didn't have the digital tools at the time. Even when I started, the digital tools were not as powerful as now, and the courts were completely paper-based. We had a revolution in the courts, and it is really impossible to underestimate the magnitude of this revolution in the Superior Court of Justice in civil cases. If the Superior Court, if the Superior Court was electronic as it is now, when I started, it would probably be a huge difference, probably make a huge difference to me. It will probably speed up my progress a lot, because at the time, and for the first, I would say, 9 years of my practice, the workflow that I had was digital, but it necessarily had a physical component because of paper filing. However, I was still able to control the physical component from any location digitally. And the way this worked is I would compose my materials, the court documents that I needed to serve and file, entirely digitally as PDFs. And then I would have a relationship with an excellent print shop where I would send those materials as PDFs with detailed instructions. That was a legal print shop, so they worked with lawyers, and they would print, bind, tab, all the accessories of our paper materials were there, the right color back sheets and everything. And they knew that, they knew how to do it. And then I would also send instructions to my process server, who would go to the print shop, not to me.
Okay.
Go to the print shop, pick up the materials, and then serve the materials, and then prepare an affidavit of service and file the materials in court. And I can run that workflow from anywhere in the world. And occasionally I would spend a month, way before COVID, years before COVID, I would go to California and spend a month and just send those instructions from some place in the Bay Area or LA or Florida was another favorite. I would just rest there and manage those people here in Toronto. So yeah, definitely helped. And I set up an infrastructure at the time that kept me afloat when COVID hit. I was ready.
Yeah, and you use the word infrastructure, but in fact, it's a complete digital infrastructure.
Right.
And what I'm hearing is you kept your overhead low, and your fees remain the same because we can't get away from those. But you keep your overhead low in order to be able to give your clients cost-effective service.
Exactly.
So tell me about your office space. I understand that are you in a virtual office space?
No, no. So that's an important amendment that I have to make to my speech about paperless and digital office. I used to be 100% digital and untethered to any physical space. I used to be. But then a few years ago, I realized that I needed some kind of home because the files were becoming more complex and dramatically more complex. And very simply, I needed more screen space than just my laptop. When a file is complex enough, I mean, I can do it on a laptop if I have to do it as an emergency at home real quick, right? But on a regular basis every day, I can just do so much better if I have more screen space. And then you immediately think dual monitors or large monitors. And once you have large monitors and dual monitors, you're tethered. I mean, no coffee shop can do that. At home, it's just not good to have dual monitors at home, in my opinion. You know, unless you have like a separate office space at home, like in the basement or something. And I just started looking for space. I found space, and it's a beautiful office. It's completely private. I have all of my things here, my files. I do occasionally have paper or physical objects, for example, sworn affidavits, but this now is really less and less relevant every day. It's really legacy things that I have, because sworn affidavits don't need to exist in paper form anymore after Ontario government amended the legislation related to this, right? So everything is digital. This is unheard of. I can tell you, one of the biggest sticks that the system would put in my wheel, in my digital wheel, was when court staff required original signatures in motion records. That was first of all, if you read the rules of civil procedure, it says the motion record must contain copies of affidavits, right? That's, well, I'm not criticizing anyone. I'm just saying this is the way things were. And it means that my client had to sign the affidavit, not necessarily in front of me, but in front of another commissioner. It's not necessary to use your lawyer of record as a commissioner. And I would have to get that signed affidavit to that print shop. And then I would have to include in the instructions, I would have to include the instruction to insert the original affidavit in the materials that they were printing. That was the reality. So that was just another layer of complexity. One more courier, one more person involved in the workflow. The more people you have involved in the process, the higher is the possibility of error. At the end of the day, I had to review everything.
Yes.
So that was causing additional delay and significantly extra costs for clients, significantly extra costs. Just to serve and file something would probably cost $300 or $500 sometimes, right? And that's unbelievable. Right now, it costs $0 because it's by email. I mean, apart from legal fees, but the service itself, I'm just emailing things, right? Or the other lawyer I worked with emailed things.
It's interesting to see and to test how each of these discrete issues is actually an access to justice issue.
Yes.
Right? What bars are in place? What prohibits individuals from actually accessing justice? And something as limiting as a signature, how that an original signature versus a digital signature, or a copy of a signature, a photocopy of a signature, how that can limit someone's access to the justice system.
Absolutely.
I want to pivot now and talk
Yes.
about what you were a little bit getting into about how you have home space and workspace. Now, is part of getting into an office because your home space has been taken over by little munchkins?
Well, partly, yes. So partly, yes. And partly it's also because a human being needs to move. A human being needs a change of scenery. I'm convinced that a human being needs a change of scenery. It's a mental health issue.
Yeah.
You need a change of scenery. If you are stuck in the same room or in the same house 24/7, this is dangerously close to imprisonment. And I, by no means, I'm purporting here to compare our comfortable homes with the conditions that people are imprisoned in here in Ontario, for example. But the effect on mental health is there. And I just read an article somewhere today that we need to measure that. We need to actually measure the other side of the lockdown. Yes, we prevented a bunch of illness, but what is the mental health effect of the lockdown? No, not taking any position. I'm just saying this is a live issue.
Well, there's a growing body of research and interest in the social side of going to work, right? Getting dressed, combing your hair, getting ready for the day, making your lunch, the schedule and the routine that goes into going to the office. And I think you're absolutely right. I think that's part of our social life. That's part of our social being as humans. But tell me about being a dad and how that's affected your practice, and how that has changed your perspective on being a lawyer, if it has at all.
It's hard to be a dad. It's hard to be a mom. And it's, I think, also a great way to be a human being. There are other ways to be a human being. You don't have to have children to be a human being, but I think one of the greatest ways to be a human being is to have children. So I don't know why people have children. I don't want to speculate about it right now. The fact is that I have children. I love my children, and I have to take care of their needs as well as my clients' needs. I owe a statutory duty to my clients, and I owe a statutory duty to my children. Has any parent thought about that? It's just to bring a little legal perspective into this. No legal advice. I mean, go, do your own research, basically, is what I tell people. Do your own diligence.
It's not usually what a parent puts on a birthday card.
Yeah, exactly.
Happy birthday. This is my 9th year of my statutory obligations to you.
Yeah, exactly. This is my 9th year of my statutory duty. I haven't yet discharged it.
Yeah. I will discharge this duty in 9 years.
Exactly. And it's 9 years to the termination of this duty. So, but I mean, we usually have good reasons for laws. I mean, generally our laws are reasonable, and they have some foundation in real life. And I'm thankful for my clients that completely understand that lawyers are human beings, and that they also owe duties to other clients or to other parties that are not necessarily clients, right? So no client has tried to hog all of my time or attention. The way I structure my work is mostly to prevent emergencies. I think the biggest source of trouble in law practice, the biggest source of mistakes in law practice, one of the biggest sources of frustration in law practice is emergencies, especially litigation. And I've practiced law for this July or June, it will be 10 years that I have practiced law. And from the relative height of 10 years of experience, I can say almost all emergencies are preventable. And they're not only preventable by doing something after you get the file. They're also preventable by doing something before you get the file, by screening your potential files, by choosing your clients. Indiscriminate accepting of files will result in emergencies. You can trust me on that. No matter how careful you are, no matter how well you plan. I mean, at the screening point, you have to screen your file for a potential to generate emergencies. And I'm not going to get into the kinds of emergencies that are possible. If you're a lawyer, for any amount of time, you will know what I'm talking about. So if your goal, however, is volume, is just sales, right? Fees, sure. I mean, you will have to have staff, though, significant staff. You will have to have significant infrastructure to support almost constant emergencies that will arise. So big firms, they are maybe more positioned or better positioned to deal with that. I don't know much about big firms, however. I was never on the inside. I always assess big firms from the outside as opposing counsel, or as a friend, or as a colleague, right, who hears about the big firm life. But they just have more capacity or more resources by definition. So it may be less relevant to them. But for small firms and for solo practitioners, I think preventing emergencies is good for you, and it's also good for the justice system, for the administration of justice. Our justice system doesn't appreciate emergencies, and it's not well designed to handle emergencies either. So you will be serving the justice system and the interest of justice by preventing emergencies, is my point.
Absolutely. And my final question, because we're just at the end of time, is forward thinking for you and your firm. And it's my final question is this: do you think that digitization and the new emerging technologies that are going to be employed by the courts is going to assist in your growth and your projections as a firm? And what are you looking forward to for your law firm and your law practice with that emerging technology?
My biggest interest in technology is not a marketing interest. My biggest interest in technology is from the point of view of process improvement. I feel that will have marketing repercussions, though. So if I improve my process, I become a better law firm. I serve my clients better. That improves my reputation. That improves my public outcomes, the reported decisions. And by the way, there are no bad reported decisions unless the judge says that you're literally a bad lawyer in the reported decision, right? So the process improvement is my biggest interest. Marketing, using technology to market, is not really my big interest because I don't do volume really. I prefer to have fewer high-value files. I used to advertise. I don't advertise anymore. I prefer content as a marketing vehicle. So process improvement is my number one interest in applying technology to law practice.
So where do you see yourself in 5 years, Pulat?
I see myself with a lot more trials behind my belt. I see myself with a lot more reported decisions. I see myself with even more calm confidence than I already have now. And I see myself meet and serve even more amazing clients that teach me as much as I help them.
It has been such a privilege this Friday morning being able to chat with you and to turn the tables on you and to hear from you. Thank you. And I am really looking forward to see not just where you, but the rest of our cohort from Osgood Hall goes. It has just been such a privilege. And I look forward to part 2 of this conversation, because I really feel like there's so many more threads that I wanted to explore. So that being said, thanks again, Pulat.
Thank you, Neha.